Hello everyone and welcome to this CPD presentation on the Owners Management Company and Agent relationship. And we're looking today at how to keep that relationship running smoothly. So the presentation today is brought to you by the SCSI and has been given CPD points by the PSRA. My name is Sonia McEntee and I'm a solicitor. For many years now, I've worked extensively with owners management companies and also with managing agents, sometimes representing the companies, sometimes representing the agents. So I've seen both sides of this relationship and how it works. I've also seen the interaction and intervention on the part of the PSRA into that relationship and the impact that that has had. And we're going to look at some of the various aspects of that today during our presentation. So the presentation itself will be about 45 to 50 minutes long. And at the end of that, you will have a quiz that you'll be asked to complete in order to get access to your points. So without any further ado, we'll move on and move into it. I've done up several slides for the purposes of the presentation today. And if you see me moving like this, it's because I'm accessing some reference material on the other screen here in the office. So the regulation of managing agents or property service providers, as they're known under the Act. So the Property Services Regulation Act, as you all know by now, introduced in 2011. So with us for 11 years now, and it has seen quite an evolution in terms of the legal framework within which managing agents provide their services. And I think as a knock-on effect, it has also had quite an impact on how both members and boards of owners management companies also react and respond to their managing agents. So it has had quite a profound effect on the relationship itself. As we go through this presentation, some of the things that we will look at are the letter of engagement, template issued by the Property Services Regulatory Authority, and for all good reasons, but we'll have a closer look at some of the provisions within it. We'll also discuss briefly some of the recent changes following regulations introduced under the Act, particularly in relation to minimum standards or what is also considered to be improper conduct on the part of a property services provider and compliance with anti-money laundering requirements. And we look as well as at the role and activity of the PSRA itself as the regulator of the profession. So in respect of the number of complaints, the annual reports that are published each year by the Property Services Regulator tell us what numbers of complaints have been received, how many have been addressed, and what the nature and form of those complaints have been. So what's giving rise to complaints? In very broad terms, the terms of the letter of engagement is one aspect. The management of accounts is another aspect. Reporting requirements, so what I mean by that is the reporting by agents back to owners management companies is a further element. And then there are complaints around what we might term project management. And what I mean by that is typically work which may fall out of the main scope of the letter of engagement, but in respect of which perhaps separate letters of engagement have not been furnished, or a separate engagement hasn't been reflected in writing. So as you can probably imagine, the number of complaints is creeping upwards year on year, but they're still not very significant. In the 2021 report from the Property Services Regulatory Authority, they indicated that they'd opened something in the order of 255 complaints that year, and that they had closed a similar amount. So while that was an increase on the prior year, I think up by about 70 or 80, as I said, the numbers are not as yet very substantial. And I say as yet because as we go through some of the requirements through this presentation, what you will see and notice, you've probably felt this already in practice, is that the requirements are getting just a little bit tighter all of the time. And there is growing awareness on the part of regulators as to the rights that consumer type clients, we refer to OMCs in that way, so consumer type clients can have, and the importance of raising awareness of what their rights are, and indeed what obligations on the part of a property services provider, or indeed any professional services provider, might be. So we'll be having a closer look at that. We look as well at the sanctions that have been imposed and it's important that there's an awareness of what these can be, how regulation will continue to evolve, and the importance of professional indemnity insurance. So just going further into the complaints and a little bit further detail on each of these issues. What I've noticed over the years on each of these are some of the following in terms of examples. So in relation to the letter of engagement, we will have a closer look at two key elements of that I have found to be quite problematic when there's a breakdown in relationship between the OMC and the agent. And the first of those is around the termination of the contract. My own view is that the template letter isn't particularly well drafted in that regard. And as I said, that can lead to a difficult termination, or termination that is more difficult perhaps than it needs to be. The second aspect that I think is also hugely relevant is that in relation to the concept of agency itself. What are you, or what can you be liable for? And what does the indemnity within the letter of engagement mean, both for you and for the owner's management company? They're going to be some of the key aspects that we're going to look at. The accounts management really speaks for itself, but in this respect, I want to reference the schedules to the letter of engagement. And these, I think, are particularly helpful in terms of what it is that the agent is going to do and what the expectation is or can be on the part of the owner's management company. It's worth taking the time to pay some attention to those, because from your own perspective as professionals, you may well feel these are the services that we always provide, or these are the services that we typically provide, or these are the services that we've been providing for years. You know, we don't need to look at this any further. But it's certainly well worth reading through those in detail, because they are quite specific in several respects. And that is the document that, or that's the element of the agreement that the owner's management company will look to most closely in the event that they have a dispute and the wish to raise issues with you. In relation to reporting requirements, it ties in with the accounts management aspect as well. And this is the reporting back to the owner's management company. And one of the most common complaints that we get in relation to managing agents is that the flow of information from agent back to OMC is insufficient. Now, here today with you, I'm not making a judgment call on what is sufficient or what isn't sufficient, but you'll find that the thrust of my presentation today is all about communication. So important to set out at the outset what those communication channels are going to be, and how often perhaps that you might be providing, you know, the likes of more structured reports back to the OMC. Because what has tended to happen, or what I have tended to see, I should say, is that that kind of detail isn't there at an early stage. And so later, when directors of the board are feeling, rightly or wrongly, but feeling disgruntled, what they find then is that they look for more information. The agent perhaps is taken a little unawares by either the request itself or perhaps the tone of the request that's made. And that's when difficulties start to arise, because nowhere has anyone committed to reports being made on, you know, a monthly or a quarterly basis or whatever it might need to be. And as we all know, that can vary from one company to the next in any event. In relation to project management, just mentioned earlier, you know, what I mean by that. And it's projects that fall outside of the scope of the standard letter of engagement. So the letter of engagement is very clear in terms of, you know, the normal service delivery or what usual expectations might be on that. But there have been so many projects that have had to be not necessarily directly undertaken by agents, but certainly managed by agents or managed in conjunction with agents over the last at least 10 years at this stage, that have been of a very significant magnitude, and have also been of a nature which has given rise to high levels of stress and distress within the development itself and within the owner's management company. So these are, I mean, the big one, I suppose, is the fire safety. And so many of you have become involved in assisting with bringing in experts, having reports generated, assisting the OMCs in prioritising works, often liaising in between with not just professional people, but also fire authorities. And for some of you, it's gone further than that, where there have been marshalling or cordoning off of areas within development. So very, very significant levels of work. And what I've seen there over the years is that it's quite a rare thing for an agent to have set out at an early stage what they are going to charge for that kind of work. And I suspect that part of this is due to the cost-conscious environment that you're operating in on an ongoing basis. But the reality is that these projects take up, as you well know, hours and hours and hours of your time. And it's important that there's proper remuneration for that, and that the costs of the agent's time are built in. At least in that way, the time then is allocated to the provision of services, and the owner's management company gets a service, gets a specific service in this example, and pays for it. When those complaints are worked through, there are some very serious sanctions that can be applied, and they're on a scale, but financial penalties of up to 250,000, and we've certainly seen instances of six-figure penalties being applied. The compensation fund is an element of what exists within the Property Services Regulation Authority, but one I think that is less likely to apply to yourselves, and probably more, or within this area of work, I should say, and probably one that's going to apply more in respect of the purchase and sales or even letting of properties. But what we have seen in relation to managing agents, and there's been quite a few of these, are the district court prosecutions for operating without a licence. And I've certainly seen, and I've assisted agents who have had complaints made about them in respect of their licences, and some fairly strict views taken on the part of the Property Services Regulatory Authority on what does or doesn't constitute the provision of property services. And it certainly seems to me at this point in time that it's particularly difficult for any party to provide a level of service and not come within the remit of that definition of property services. In any event, you're all licensed operators, so it's not going to arise. But within the district court, there have been several prosecutions and convictions for operating without a licence, and the fines imposed have ranged from a couple of €100 up to 15,000 or 16,000 euros. So the implications of that are very serious. I suspect for most of you, having been through the licensing process so often now, that you're well familiar with what it is and what it means and what is required, and you know what to do on an annual basis. How will regulation continue to evolve? I think the key point here is that the Property Services Regulatory Authority will be keeping a close eye on what the nature of the complaints are that are being lodged, and that you'll find that regulation will evolve from that. And I think one of the key examples of that is the 2020 regulations that were introduced, and which cover areas directly affecting yourselves, such as acting as a director within the owner's management companies, and also some insight, I suppose, or some definition of what improper conduct means. Because in respect of the complaints that had been lodged against property services providers, something in the order of 60% of them had been dismissed because the conduct complained of was not considered to constitute improper conduct. So those regulations will give you some certainty around what the PSRA will consider to be improper conduct, but bear in mind that also educates the public in terms of what and how they see improper conduct. The importance of professional indemnity insurance. You might consider that in many ways the work that is done by the managing agent won't necessarily come within the remit of your professional indemnity insurance. But the reality is that the professional indemnity insurance is there to cover negligence on the part of any professional services provider. And so often when I'm speaking to people about negligence in this regard, what one person would call negligence, another might refer to as human error or oversight or mistake. So there's a damning connotation which attaches to the word negligence. but your PII is there to cover what might in effect be mistakes that are made, or human error, as I said, or oversight. So I've mentioned the letter of engagement several times, and it is important to use the services and the resources that are there to your benefit and to introduce efficiency right at the start. As I've said here, be upfront with the OMC in relation to the conversations that you had at a time when you may be seeking engagement or tendering for services. Fees aren't the only important topic for conversation. And if a conversation is reduced only to fees, the owner's management client won't fully appreciate what it is that they want you to do and the service that it is that you provide. But getting back to the letter of engagement, the objective in introducing that letter of engagement was to assist yourselves as a profession in having a fully formed legal contract that could be put in place with your OMC clients. So it's there to protect you, there's no doubt about that. Also there to protect the, as I said earlier, consumer type client, which is the owner's management company. And one of the benefits for the owner's management company being that having a template letter like this would mean that they shouldn't need to seek out legal advice each time they wanted to engage with a managing agent. But there are several clauses within it that have given rise to some problems. And I want to just make reference here to what is called the contra preferentum rule. And the contra preferentum rule is a rule in law which makes an assumption that where there is an ambiguity in any construction of a contract term, that the interpretation of that would go against the person that has drafted the contract. And by extension, the person who is professional in the area as opposed to the person who is consumer type client. So just to be aware that where there is dispute or ambiguity in relation to any of the clauses within your letter of engagement, it's quite possible that a court would make a decision that would be influenced by the fact that you're the professional person and you know and understand this business better than anyone, as opposed to the owner's management client, who in most cases is, a consumer, is an ordinary person in the sense that they're not professionally trained in this or professionally legally trained. Some of these clauses are the indemnity, and I'd speak about them briefly as I go through them, but the indemnity clause, I mentioned earlier, what this is there for your protection, and that's clear enough. And you need to be given the authority and the autonomy to get on with the role that it is that you have to fulfill for the owner's management company. But it's really important to be clear that that indemnity is still limited and won't cover you in circumstances where either you haven't fulfilled your obligations under the contract, or you have acted beyond what the contract authorizes you to do. So when you have that relationship with your OMC client, again, going back to your schedules or going back to project management, if there's a project there to be managed, it's really important to set out the scope of what it is that you will do, or indeed what it is that you won't do as part of the service that you're offering. And that's how you can secure more fully the indemnity that's there for your benefit under these contracts. The dispute resolution clauses can give rise to some difficulty as well, and I think mainly for two reasons. Firstly, the nominated person to whom any disputes should be sent tends perhaps to be the agent who's most directly involved with the management company, as opposed to someone who is somewhat removed. So it doesn't have to be an external independent person in that sense, but perhaps, and maybe in some of the bigger companies, but perhaps someone who's in a position of seniority within the company would be that person, someone who is willing to sit back and objectively and critically assess the services that has been provided by their own company, and will listen to what a complainant has to say. That's one element of it. But the second element of it is, what happens after that. So even if the nomination part is done well in terms of the right person is identified, and someone with a long-standing connection with the agency itself, but what happens after that is also I've seen it to be problematic. The reason for that being that the dispute really isn't addressed. So I mentioned earlier that this is all about communication. to have a process in place around the management of disputes. So I'm not suggesting for a moment that this goes into the letter of engagement, but in an ideal world, maybe it would. But for your own benefit, that you have internally, for example, an acknowledgement of the complaint within maybe 7 days, a preliminary response to the complaint within maybe 21 days, and that there's a process that's rolled out there, because firstly, that sets a time frame for you within which to deal with it, which means that it shouldn't get set to one side and get left behind, because in those circumstances, it just grows, it just gets worse. But on the other hand, for the OMC client, what they see is that, firstly, that there is a process, and secondly, that they have some idea of what to expect as you go along. Now, as you have that process in place, it's really important then to comply with it in the event that you do get the disputes in. No more than the complaints that are made into the Property Services Regulatory Authority, if a complaint into the agent is addressed at a very early stage, it's far more likely to be resolved. And where these tend to grow and get worse is where they're not addressed at an early stage, and particularly where the OMC client feels that there's a lack of communication or a lack of engagement in reverse. The termination clauses within the letter of engagement also problematic, in the sense that my own view is that there's some conflict even within the clauses as they are drafted themselves. Where there's to be a voluntary, where an agreement is to be terminated by, where a letter of engagement is to be terminated by agreement, obviously that's fine, that situation speaks for itself. The OMC client and the agent will agree what an appropriate term might be. But where it's to be unilaterally terminated and there's a notice period allowed for, I've seen those notice periods be for up to 12 months. And I think that the problem there is that the agent expects that they remain in place for that 12-month period. The OMC perhaps has already decided that the OMC doesn't want the agent there for that continuing period. And where that level of, where that trust in the relationship has broken down completely, it has broken down completely if the agreement's being terminated. It doesn't benefit either party, and I think that's just lining you up for a bigger dispute and potentially complaints that go onwards to the PSRA. So without telling you what your notice period should be, I would simply just suggest that a lengthy notice period like 6 to 12 months simply doesn't work. It doesn't work for either party. And on the one hand, while you might feel that it's protecting you, protecting your business, it's simply not going to work that way. The schedule of services I've already mentioned and talked about. And again, just to repeat the point around that, just to go through it line by line and make sure that you are satisfied that they are the services that you're going to provide, and to be familiar with the language around each of the description of the services to be provided, because that's where the expectation for the client is set. The managing of information, GDPR, company law requirements, something I've come across on a number of occasions, have been breaches of GDPR, or I'll say misunderstanding of GDPR, and also perhaps a misunderstanding of company law requirements. And sometimes these arise in what might be relatively innocuous kinds of circumstances, and the impact of it may not be terribly severe. But it's important that there's a recognition that as agents, you are obligated to manage information for the purposes for which it has been collected, to only use it for that purpose. There are also issues around the retention of that information post termination of contract, for example, and to have policies in place around all of that. I will mention briefly one that comes up pretty consistently around where GDPR is used, and it's around the provision of an access to the register of members for the owner's management company, which often goes firstly and maybe only to yourselves when that request is made. The obligation under company law is that access to that register must be granted. So GDPR is not an exception to that. The register of members is in law a publicly accessible document, and it must be furnished. The second point with that, and it's related to GDPR as well, is the keeping of the register of members, and again an obligation that tends to fall back to the agent. And company law sets out quite clearly what the register of members should look like. And I will have to maybe express some sympathy with you on this particular point, because I understand that for the vast majority of you and the vast majority of the owners management companies, you will not ever have been provided with a properly set up register of members, and so the Excel sheets are used to detail the information. Company law dictates that the only information that is maintained on a register of members is the name of the member, the address of the member, which may or may not be the unit owner within the estate, the unit within the estate that you're managing, but the address of the member, the date upon which they became a member, and then the date on which they ceased to be a member. So in fact, no one's name should be removed from the register of members. It's really, think of a hard copy book, hard-backed book, if you like, where simply you'd just be turning a page and adding on names at the end. And that's the only information which should be in the register of members. And I've seen, what are presented as registers of members, which include the unit addresses, in addition to perhaps residential addresses, which include email addresses, which include telephone numbers, that kind of information. So all of that is problematic from a GDPR perspective. I will say that, and some of you will have done this and seen this, but it is possible to amend the company constitution to include clauses that allow for a little more flexibility around the management of unit owner information in the context of outstanding management fees, and that's something that can be done, but I won't go into that here. But in any event, I'm saying it's about clearly setting out at the outset what it is that you are going to do and what it is that you're not going to do, and to have some processes and procedures built in around the services that you provide. I mentioned briefly the 2020 regulations a few minutes ago, and the impact of those, meaning that the number of admissible complaints is likely to rise into the future. And that's really just awareness of what improper conduct might be. And some of the examples that are given within the legislation around what might constitute improper conduct would include holding yourselves out as possessing experience, competence, training, or resources that you don't possess. So just consider that word competence very clearly, very carefully, in terms of the services that you're offering. Accepting any form of inducement, so being a reward, advantage, or an enticement other than the agreed fee. Very many owners management companies are suspicious of agents getting payments from third parties for appointing those third parties. So it's really important now to be aware that accepting any form of inducement in terms of the how services are contracted into the owners management company will now constitute improper conduct, and you will find yourselves in difficulty if that complaint is made and if that can be shown against you. And just on that particular point, bear in mind that where a complaint is made, the obligation on the part of the Property Services Regulatory Authority is to investigate. All right, so what that has meant to date is the complaint is received, it's sent on to yourselves, you're given the opportunity to respond, and that perhaps then is sent to, may or may not be sent, sometimes it's an interpretation of it is sent on to the OMC, who then might respond further to what has been said, or to a preliminary assessment made by the Property Services Regulatory Authority. But the obligation, in fact, is to investigate. So in terms of the response that you send back to a complaint that has been made, the PSRA itself can assess your response and come back to you with further questions or queries, or asking you to substantiate maybe certain things that you have said. So just be mindful of that. So it's not as simple as, I suppose, you presenting your case or your reply. The PSRA itself does have the legal authority to come back and probe that further. The other one then that I mentioned earlier was in relation to acting as a director of an owner's management company. So there is a carve out there where maybe you own a unit within that particular development, but other than that you shouldn't be acting as director. And I think that's a positive step forward, and my experience in the last couple of years has been that I don't tend to see agents acting in that, or haven't tended to see agents acting as directors in the OMCs anymore. Anyway. So with that additional clarity, as I said, just means the number of admissible complaints likely to rise. So again, think about and work out what your process within the office is going to be for dealing with a complaint. And I suppose if I can say this to you, people will complain. I mean, they just will. And what I've seen happening in the last several years now is that regulatory bodies make a lot of information publicly aware around how the public can make complaints about regulated service providers. So the public are becoming more and more aware. So complaints will be made. Complaints will be made that are utterly unfounded. There's no doubt about that. And unfortunately, you're just going to have to read those, review those, and respond as you need to respond. Some of the complaints that are made may well have some substance to them, but can be very easily resolved. And I've certainly seen that the PSRA works at an early stage to try to see resolution brought to complaint circumstances. And I suppose my advice on that would be that if you can bring any open complaint, if you have the means of bringing that to a conclusion at a very early stage, that's the way forward, that's the way to go. Another piece of advice in relation, because where I'm going with this really is not to take the complaints personally. So, and that's easier said than done, but not to take the complaints personally. So even in terms of complaints that are received, you know, put them aside even for a day or two perhaps, and then pick it up and read it again, because anyone's first response can be, that's not how it was, this isn't what happened, they're wrong. But put it aside for a day or two, take it back up, read it again, or maybe have a colleague have a look at it for you and just say, you know, what do you think of this? Before you prepare your response and send it back. All right, so as I said, easier said than done, but the complaints aren't taken personally because frankly, they're just going to happen anyway. So these regulations, back to the 2020 regulations, the regulations also allow for a broader assessment of the role that the agent plays with the client. So communications, the method and timing. So back then to, I mean, I've talked about clarity around the letter of engagement. I've talked about clarity around the management of complaints. I've talked about more clarity around the termination. Again, something that is, you know, an unfortunate business transaction, but it is a business transaction and best treated, I suggest, in that way. Less likely to give rise to, firstly, dissatisfied clients, because we all know that word of mouth referral is still a major source of business development. But secondly, less likely then to lead into potential complaints later on. An obligation to take into account the best interests of the client. Sometimes I have felt in the past 10 years or since some of this legislation was brought through, and the Multi-Unit Developments Act as well, that what is reflected on paper is how things had been happening anyway. But this now formalises it, the obligation to take into account the best interests of the client. The taking of instructions in a timely manner and in an appropriate manner. And again, my advice to you would be the confirmation of instructions in writing, even if that's only by way of an email back. You've asked me to do or following your phone call, I've attended to the following, and have those confirmations in writing and keep them on your file. Very easy to, and at least email searching nowadays is much better than it used to be. But ideally, you have a separate file someplace else so that those perhaps more important communications can be not necessarily removed altogether from your emails, but can be copied out and onto a particular client file as well. Using funds collected appropriately. Again, I have to say it's been very many years since I've seen this kind of issue arising in the context of an agent. But what I have found a couple of times in the last few years is that monies that have been paid into the agent, that there has been probably more to do with a delay in explaining what was done with money, how they were managed, where they were lodged to, what date they were lodged, or if it was used to pay something else, what it was used for. So again, timely communication on those, and the managing of conflicts of interest. So a conflict of interest really won't be problematic if it is disclosed at a very early stage and So the board of directors are made aware of whatever it happens to be, and they agree to proceed with business with you on that basis. So once again, it's about putting it out. And you know, this may be, for example, in relation to lots of managing agents that I have done work with provide ancillary services through related companies. Nothing wrong with that, absolutely nothing wrong with that. But one point of dispute or complaint that can come up later is, well, you the agent, were providing all of these other services as well, and you didn't make that clear to us. You know, why were you not tendering? Why were you not doing? Why did you not make this clear for us and set this out for us? And the objection really there is, somehow we're happy with you, the agent, so now we're going to look at everything that you've done and make every complaint about you that we can. So if it's a case that you also work to provide ancillary services into the OMC, make that really clear at the start. Take up the work on the basis that I suppose if they went out to seek those services elsewhere, you would be in the running for that work anyway. So some of these points I have dealt with already, but we will run through them again. So acting as agent, what's the legal framework? As I said earlier, this is there are two aspects to this, and this is where you need to take real care. Acting as the agent and the protections that you have in acting as an agent will work very well for you, provided you act within the scope of your authority. And it's the letter of engagement that sets out what that authority is. So as you will know, although it doesn't happen as much anymore, but regularly in the past, agents would have signed contracts or signed other documentation on behalf of owners management companies, and all of that was binding on the owners management company on the basis that the agent had the legal authority to bind the company in that way. I do think that where an agent may still be signing documents on behalf of an owners management company, that there is more organisation around that, and there is a recognition that a formal letter, a formal instruction or a formal authority directly from the owners management company to you as agent to do that is required or should be put in place. But to repeat the 2 points that I made earlier, and I think if you go away from this session today with little else other than this, I think these are the 2 key points. That agency agreement will protect you for as long as you act within the scope of your authority. So if you fail to act in accordance with your obligations under the letter of agreement, then you're potentially in difficulty. And that may be for several reasons. There may be a breach of contract there. There may potentially be negligence there if damage arose as a consequence, or indeed your indemnity may fail to protect you. The indemnity that's written into the letter of engagement may fail to protect you in those circumstances. The flip side of that is where you've acted and have exceeded your authority. So again, go back to, I think the really good example here are some of those, I'll use the larger projects, and it's really to make the point, but it applies to anything that arises outside of the scope of your letter of engagement. And I'm really aware that there are huge pricing issues and a lot of competition out there in terms of what we might term the regular managing agent services that are provided into OMCs. So I suggest to you it's really important for yourself that once an owner's management company steps outside of that framework, that you have a separate letter on your system ready to go, which says this wasn't covered in our original agreement, and this is how we're going to handle it, and this will be the person who will be responsible for it, and our rate will be. And approach that on the same basis as you do with the letter of authority, that if it's with the letter of engagement, sorry, that if it's not in place, well, then you're not authorised to do it. And that's the way to put it to your owner's management company. You want this work done. I'm here, I'm happy to do it. I have the competence, remember that one earlier, I have the competence to do this for you, but I do need you to recognise that this is beyond the original scope of our agreement, that there will be additional costs. Agreed. When you're being properly paid, you will give the time that it takes to getting those jobs done. And we're all under increasing pressure, both in relation to fees on the one, downward pressure on fees, and of course upward pressure on the services that are being provided. So the authority to bind the OMC, so I've mentioned that briefly, and in dealing with third parties, in dealing with third parties. So I say here, I've used the term actual as opposed to an implied authority. You know, as far as possible, you should never work on an implied authority from your client. Some things might be really obvious, but where you're stepping beyond, and again, repeating myself, but where you're stepping beyond the schedule of services that's attached to your letter of engagement, do have a separate letter ready and available to issue, and do issue it, and do look for the client to acknowledge it before you get very actively involved in whatever that is. Make sure your letter of engagement has been signed. These are your contract terms, right? They're there to protect you as well as to protect the owner's management company as well. The benefit of the indemnity. So the indemnity is an exemption from liability for losses. However, when you go beyond the scope of your authority, said that already, you may not be able to access that indemnity in the same way. So read the terms of the indemnity really carefully. When might an indemnity not provide cover? We've already addressed that. And what happens then under the law? Well, then you're liable for the actions that you've undertaken or the actions that you haven't undertaken. And, you know, as a solicitor then, what I'd be looking at is, where has the contract been breached, or how has the contract been breached? Has there been negligence here? What are the losses for the owner's management company? One of the really challenging elements on this, though, is that the vast majority of issues that will arise will be destined for either the district court or the circuit court. So it will be quite unusual to see disputes with managing agents finding their way into the likes of the High Court. And within the district court in particular, and largely within the circuit court, we don't get written judgments. So firstly, where any dispute might be resolved without going into court, the terms of that resolution will remain between the parties, or they're not publicly available in any event. And secondly, where there is a judgment given, unless there's a written judgment provided in relation to that particular case, no one else knows about it. It's not published anywhere. And so it's really hard to get access to that information. So that also can work for you or against you, because there's less access to information around these concepts. So reporting requirements, I said here again, for a satisfied client, the greatest source of dissatisfaction within OMCs and by extension their members is around communication. So good communications resolve most difficulties, and clear processes and procedures from the outset. I say here, set boundaries with the client, but you're the people who better know how the relationship should work, or how it's going to work perhaps. And you know what's involved in this job. For very many people, and you also know this, but for very many people that you're dealing with, they don't know. All right. So the opportunity is there for you to set out what the processes and procedures are going to be. And, you know, I've set out here, I suppose, some of them are principles, if you like, in terms of communication with the client, but that it's timely, that it's informative, that financial information is furnished. Ideally, I think for you, within agreed timelines and within agreed formats. So you know what your standard format is. So say to your client at the outset, well, we do this reporting on, you know, a weekly basis or a monthly basis, or whatever the time frame is. But they'll want to see the financial. They'll want to see the financial, because it's just an unfortunate truth that there's lingering dissatisfaction with agents, and I suggest that it has wrongly hung over from an era when there was so much less transparency around the management of the OMCs and the accounts and the money that went into them. Seeking your instructions. Again, go back, whatever you're asked to do, if it's not already within the scope of your letter of engagement, make sure that you get a separate instruction in writing. Think further about the potential complaint in the future. Things may be great with your client today, but think in 3 months or 6 months down the road when something might happen and they're not great. Or there's been a change in the board and you're now dealing with different people who see things a little bit differently. So think forward to a potential complaint into the future and make sure that you have your instructions on the file that you can say, I was asked to do this. Make those instructions, ensure that they're as comprehensive as they can be and as clear as they can be. And again, what you will do, but also what you won't do, if that's important to state. Transparency in business. So this goes back to your 2020 regulations and best interests of the client, disclosure of conflicts of interest, not accepting payments from third parties, those kinds of principles. Meaningful engagement, which I think is probably a combination of all that has gone before. And the last one that I have here is dealing with difficult OMC directors. And I think we've all experienced this. I've certainly experienced this too. And from time to time, there will be some directors who they may be well motivated, they may not be well motivated, they may have an agenda there. And I think that what tends to happen is the OMC directors being, they may be neighbours, or they're unit owners, they may be living there, maybe they're not living there, but I suppose they're of a more neighbourly disposition, or that's how they set out. You're the professional person coming into the room and bringing that professionalism to the business that needs to be carried out. And I do think that there's a role for the agent to play here in terms of setting boundaries as well with that difficult director. Now, the difficult director may be difficult with you on the one hand, or it may be that they're being difficult with the board and playing back to, let's say, an audience amongst the members. And we've certainly done some things with some companies over the years where incoming directors have been asked to, expressly acknowledge very specific obligations on their part around confidentiality as an example. So just trying to drive home those commitments on the part of board members that they do need to act, the board does need to act as a unit, and it does need to speak with a single voice, and the discussions that go on inside should be maintained in a confidential manner. And where someone disagrees within the boardroom setting, let's say, that once they go out of the room, they recognise that they simply can't go out and spread that dissent. They leave their disagreement inside of the door. If the majority decision is made, well, then the company is bound by, or the board is bound by that, and everybody moves on. So I think there's I think the agent has a really useful role to play there. And I say that wholeheartedly, recognising that from time to time, there will be people that simply can't be managed in that way. So we'll be moving quickly on now. The key is to take expressions of dissatisfaction seriously and face up to them. It's all part of business. And by dealing with a complaint in a professional way, you have a much greater opportunity to bring it to a conclusion at a very early stage and maybe even resolve it. Sometimes what people want more than anything is a little attention. A clear dispute resolution clause that will eliminate dispute over how to progress that. So both parties have signed up to the start. We talked about who you might nominate in terms of someone within, it may be within your office, and maybe it's someone outside your, but someone who can assess a little more objectively what the situation is. And then that there's a process behind that, and you move forward in that process. And that's something that, a good administrator in the office should be in a position to help you with. And they'll prompt you, we need to issue this, or we need to issue that. Have you attended to this part? Have we got that information? And help you to put together whatever it is. So as I said here, because staff members change, nominate a principal of the business or a person in authority who can objectively assess the issue that's being complained about. Clients do accept that mistakes can be made. The key to retaining business and maintaining the good reputation would be to fix the issue and to maintain that standard going forward. And very often the issue that's there is actually a communication issue, not about anything else that you have done or haven't done, actually about the communication issue. So bear that in mind. And, and I say that also as someone who finds the likes of emails incredibly difficult to manage in terms of their volume, and a phone that never stops. But put in place a process around those and maintain that process. I said here, under promise and over deliver. once again, easier said than done, but I suppose that's the principle if we can apply it. So in relation to termination of services, termination as opposed to expiry, as I said earlier, something has clearly gone wrong in the relationship. Assess objectively the nature of the client and how business has been, because sometimes it's better to let it go, or it might be better to let it go. And assess that for yourself, you know, and without in a detached kind of a way. Do I let these people go? As you know, because the owners management company clients themselves are far more aware now of their ability to tender for services. You know, managing agents typically all have websites. It's easy to find you. It's easy to compile a list of 10 agents in the you know, in the local area who we might approach for a contract. So you will win. There will be more business there to be had. And sometimes it's important just to recognise that the best thing for you is to let something go. Clear drafting of the termination clauses. And again, I mentioned that point earlier about the term for unilateral termination. Can a relationship really work if trust is gone? Or if there's a unilateral termination, are you better really sitting with the client and saying, you know what, you've expressed some dissatisfaction with us. We have found this relationship is not really working for us either. Why don't you you start looking for your new agent? We'll start getting all of your information together. You'll pay our fees. We'll provide you with your information. Your new agent comes in and everybody gets on with life. Mentioned earlier the vagueness or ambiguity. There's every likelihood that they would be resolved in favour of an owners management company, particularly where they haven't taken legal advice. The use of that letter of engagement, in fact, the template letter of engagement isn't mandated. So the PSRA does accept that and there can be revisions or amendments to it. But what I can say with almost absolute certainty is that the owners management company won't be taking legal advice around the execution of that contract. So that does place some additional responsibility on you to make sure that there is clearer drafting around those clauses. Where termination occurs, I've said comply with ongoing obligations. I see here the spaces have been missed in some of the slides, so I need to correct that. But where termination occurs, comply with the ongoing obligations. Use the PSRA drafted schedules to prepare handover documentation, and impeding a new agent won't reflect well. What we tend to see on that issue, though, is you can have your information when you pay our outstanding fees. The first point maybe to make on that is you shouldn't ever be in a position where fees outstanding are very extensive. All right. So that you're invoicing regularly, that you're collecting regularly, which obviously means that the management of the service charge income is going reasonably well, or is going well enough to make sure that you're being paid. So make sure that you're getting paid as you go along. And if this situation arises and there's a dispute over outstanding fees, it's for a smaller sum rather than a larger sum. But the handover of the documentation is a separate obligation under the contract to the payment of charges. They're not connected. So I don't think it will reflect well on you if there's a refusal to hand over documentation in circumstances where you haven't been paid, and particularly if it's for, let's say, a lesser amount rather than a greater amount. But you do know, of course, that for the vast majority of owners management companies that litigation won't be considered feasible, but that's where the PSRA will be utilised further, and that's what will fuel the increase in the numbers of complaints going forward. So again, just in terms of your letter of engagement or a supplemental letter of engagement, if I put it that way, where there's a separate professional service, there are new terms to be drawn up. Take expert advice where it's required. Consider the time and cost involved. Going back to the expert advice again, think competence. Remember, you have to, whatever you do has to be within your own competence. If there's expert advice required, seek out that expert advice. You serve your client better by ensuring that the advice comes from the right person. Consider the time and cost in this additional work, and that's the time for you and the costs to you of being involved in it. Agree clearly how it will be paid, and allocate sufficient resources to following that work up to completion. And then I've said it's likely to tie in to a certain extent with routine obligations. So for example, members' meetings where they may be reporting back, that sort of thing around So look, we found that the industry since the introduction of the 2011 Act has become much more professionalised. Clients are more demanding, both in terms of awareness of legal obligations and rising expectations of service providers. But as said throughout the presentation today, the most common complaint that we receive comes back to one issue, and that's communication. So that's just a little bit about myself in terms of having been invited to make this presentation to you today. As I said earlier, there will be a short quiz that will follow so that you can claim your CPD points around it. And thank you for your attention.